Okay, Michael, we're live on Facebook, is that right?
Yes.
All right, I'll go ahead and get started. So hello, everybody, and thank you for joining us. I'm Christina Rosales, and this is the Texas Housers' first COVID response call that is open to the public. So we intend to hold this kind of monthly call to create a space to hear and discuss urgent issues during the public response to the housing crisis brought on by the pandemic. The agenda was organized by my colleague, Eli Barish. So if you have any suggestions for future calls, you can email him at eli@texashousing.org. And just a couple of announcements. If you are on the Zoom with us, that's great. That means you're part of the inner circle, if you will. But if you are not speaking, please mute yourself and your video so that we can have our Facebook broadcast just the speakers. And then also feel free to share highlights from this call on social media. You can tag us at Texas Housers. So we'd like to take this opportunity to introduce you to two major projects by Texas Housers. I'm going to share my screen for just a second so I can show you because we are very excited about this. Great. All right. So you are looking at this website is called keeptexanshoused.org. In it, we are tracking evictions around the state, and we are offering policy suggestions, as well as building a base of fellow advocates whose voices and work will be very necessary during this time. I want to highlight three things. First, you can find our eviction scorecard. Let's see. So we have a number of scorecards. First is the eviction scorecard. We have analyzed a few major jurisdictions and analyzed the equity of the scorecard. So you'll see that it is intended to be a tool to show the discrepancy between how more and less vulnerable populations have been affected by COVID-19. And you can click here to download it, and we are happy to answer any questions after this call about this. The second thing is we've launched a local policy scorecard. We've taken a number of characteristics, including overall financial assistance, transparency, and legal protections, and rated a few major jurisdictions on those characteristics. The higher the score, obviously, the better they're doing in response to COVID-19. And finally, the late rent clock is a real-time estimate of late rent in Texas. So currently, our estimate indicates that there is $3.2 billion in renter debt in the state of Texas, and that includes late fees. I'm going to hand this over to my colleague Eli Barish, who worked on the latter two projects, so he can explain just a little bit more for 1 minute.
Yeah, thanks, Christina, and thanks again to everyone who's come, especially the four judges. We really appreciate you sharing your time. Christina, if you want to go back to the scorecard for a minute, I'll talk about that first, and then the rent clock. So the scorecard came about because when the CDC ordered a halt to evictions, one of the things they said about their emergency powers is that they're empowered to take action when local response has been insufficient. And so I think it's important to have an open and honest conversation about where city and county governments have succeeded and where they've fallen a little bit short. So this scorecard is meant to do that. It's meant to facilitate that conversation and be kind of a one-stop shop for understanding the three biggest components in our view of local government response. And those components are the rental relief and financial assistance, the transparency they've created for accountability to their constituents, and then third, various legal protections. And so just very briefly, and again, you can download a methodology, the financial assistance is basically depending on how much money cities and counties have allocated for rental relief and direct assistance, which includes other household needs like utilities, nutrition, et cetera. and that's modified by the income limits that cities and counties put on the relief funds, because certain programs, they allocate a lot of money, but because there are no eligibility restrictions, middle and even upper class residents can get access to those funds, and the neediest residents can't. So that's the financial assistance component. The transparency component has to do with whether a city or county has created a live dashboard that shows how they've spent their rental relief dollars and the demographic makeup of who those dollars have gone to. And then the legal protections, we have a checklist of different protections that cities or counties could undertake to protect renters, like creating a right to cure, or in the case of counties, JP's deciding not to hear eviction cases for a while. And so that's what's reflected there. So you can look at a composite score or the individual scores. And this is a living document, and we're going to keep working on it, but we hope that it's useful to everybody. If you want to go to the rent clock. So we've also created a live rent clock that shows the accumulated unpaid rent and late fees in Texas. The URL for that is texasrentclock.org. And what we've done here is basically use two recent data sources released by the Census Bureau to estimate a real-time look at accumulated renter debt in Texas. The issue is, with the CDC moratorium and the prohibition on evictions for non-payment of rent, there's a real risk of this becoming an out-of-sight, out-of-mind issue, when in fact, late rent has continued to accrue because the economic situation has only marginally improved. So we think this is a really valuable look into, a slow building crisis that everyone should be paying attention to. And just for reference, other analysts have tried to analyze these same numbers, and our estimates are well in line with what other analysts have come up with. Stout, for instance, estimates the January 2021 rent shortfall. Their upper range is $3.2 billion. Their estimate for number of evictions, this is just in Texas, is 780 to 862,000. So, our numbers are right in line with what others have come up with. If you want to read more about our methodology, it's fully downloadable. And the rent clock, it'll continue ticking up, and so this is a tool for us to kind of measure this crisis in real time. So I hope you'll take a look at it. I hope you'll share it on your social media, and I hope you'll use it in your work. Thank you.
Thanks, Eli. I'd like to acknowledge two volunteers who helped make that happen. In addition to Eli, my colleague, Mark Bucchieri and Austin Pate have both helped with this project. So let's get to the main event. We wanted to host this call because as of late, almost all housing news has been about evictions. The pandemic began in March, and what followed were an onslaught of actions, including the CARES Act protections, a patchwork of local ordinances, a Supreme Court emergency stay on evictions, and millions of dollars in rental relief from some local jurisdictions. And the latest is a moratorium on evictions brought up by the CEC. So experts predict an eviction crisis unlike anything we've ever seen, and justice of the peace courts are ground zero. And that's where our focus is in today's panel. Our moderator today is Nelson Mock, and he's one of the most experienced housing attorneys in the state. So it is my pleasure to introduce you to Nelson Mock from Texas Rio Grande Legal Aid.
Thank you, Christina. And I'm here I work with Texas Rio Grande Legal Aid in Austin, Texas, but of course our service area is from El Paso to Austin to Corpus Christi south. We have the entire southern border of Texas. Basically, we cover a third of Texas. These are incredibly difficult times for our clients, low-income Texans in particular. And we hear, we get calls every day with people expressing their misery and fear. We are overloaded by people who are seeking legal help. And in particular, people who are facing this housing crisis that we're having. So if you can imagine all of the fears that people have with the potential of being evicted before the pandemic, you compound all of those with the health crisis and the health fears, and it makes for a very difficult situation for everyone, obviously. This is also a time of evolution. Courts are moving by necessity and efficiency from in-person court hearings to remote hearings for various reasons. But that also poses a problem for many litigants who fall on the other side of what they call the digital divide. As Christina mentioned, justice courts are ground zero for a lot of these questions because justice courts have the original jurisdiction for evictions. If a case for eviction is filed in the state of Texas, it must be first filed in a justice court. We are very lucky to have the 4 judges before us today who have an incredibly diverse legal and policy background to discuss what they've seen, what their courts are dealing with, and what they anticipate may happen in the future, because obviously none of this is over, and there are a lot of obstacles to the administration of justice. So let me introduce them very briefly, and then we'll get to talking about the current situation. Judge Jeremy Brown, the first judge I will introduce, it was raised in Houston. He is Harris County JP, Precinct 7, Place 1. Jeremy has worked as an attorney in private practice in the area of criminal law and family law, has focused a lot of energies on voting rights and fair justice systems, but he also has a policy background. He worked as a policy advisor for a city council member and as a legislative aide for a state senator. And one thing I'll point out, I'm sure that he's going to talk about some of the programs that he's worked on, but Judge Brown was very prescient last year when he started an eviction prevention pilot program in partnership with Texas Southern University. So we look forward to hearing a little bit about that. Judge Jeff Wentworth, very, very happy, honored to have you with us, Judge Wentworth. Judge Wentworth has done it all. He's a former U.S. Army counterintelligence officer, former congressional assistant, former county commissioner, former regent of the Texas State University System, former state representative, and then before he was Justice of the Peace, a former state senator. And I did not know this, but he is a 4th generation Texan, and he was born in Mercedes in Hidalgo County, which is in our service area in the Valley. And our third judge today, Judge Sasha Moreno, she is a Dallas County JP, Precinct 4, Place 2. And as a lawyer, she practiced both in state and federal courtrooms, focused on immigration, but also foreclosure defense and corporate transactions. And she, interestingly enough, has a master's in dispute resolution. And I'm sure that comes into great play in your role as a judge, Judge Moreno. I loved your comment on your website that your commitment to justice and equality was instilled by your grandfather who immigrated from Mexico in the 1950s. That's a great legacy to follow. And last but not least, Judge Chu, welcome. Judge Chu is JP at Precinct 5 in Travis County and has been particularly busy during the pandemic. Previously, Assistant District Attorney, Chief Misdemeanor Prosecutor. He's a community activist, proud son of immigrants, and is currently the chair of the Supreme Court Working Group on COVID-19 and Justice Courts. I'm actually not sure what the actual name of that work group is, but I can tell you that it is a very active work group and has been involved in a lot of advising the court on a lot of the things that have been happening. And it's great that he took the reins of that. And it's always fun to find to see what you can find on the internet as well. Judge Chu is the grandson of the owner of the first Chinese restaurant in Grapevine, Texas. So welcome all of you all. Thank you so much for being here. It's really an honor and a privilege to moderate this panel with you all. Let's get started. Let's set the stage. Let's talk a little bit about what the courts were like before March of 2020. And maybe let's talk about San Antonio, Judge Wentworth. If you could talk a little bit about trends in housing and evictions that you were seeing in your court before March 2020. What did your courtroom look like at the time?
Well, the courtroom currently is me sitting in my chambers looking on my TV screen. Prior to that, of course, we were in the courtroom. We had 4 eviction dockets a week, and we had dozens of cases usually on each docket. I'm going to guess about 2/3 of those dockets were resulted in default judgments. Tenants just wouldn't show up, and so default judgments were signed. It's been substantially changed in my court, of course, as it has across the state. I didn't much like the idea of Zoom as it was explained to me, but now that we've worked on it, it's working pretty well. And for those few people that can't Zoom, they call on the phone. And if for instance, one party is on Zoom, I just have them call my chambers directly and I put them on speakerphone and we do it that way. So it's continued, although I've got to say, because of the rental assistance program in Bexar County and San Antonio, we've had fewer cases in the last several months than we did prior to March. There've been a noticeable decline in eviction filings, at least in my court.
So the Office of Court Administration, their data indicates that the number of landlord tenant cases had been increasing significantly in the last 5 years. And your description of 4 dockets of people, and I'm assuming that you have you would have, when this is before March, of course, you would have a full courtroom of people, despite the fact that you had a lot of default judgments.
Very often that is the case. As a matter of fact, I've complained I need an extra bench at the back of my courtroom, because I actually took a photograph to send to the facilities court manager, because I had people sitting on the floor in my courtroom at the rear of the courtroom because we didn't have enough seating.
Right. How about you, Judge Moreno? What were things like before March of 2020?
Very similar to what Judge had just mentioned previously. We would have 3 to 4 dockets depending on the amount of cases we had filed. And typically we would sit anywhere from 30 to 40 cases for each docket. And most of the time it was a majority defaults, but it could also every day vary, where, one day we would have a lot of contested cases versus now. I am not just solely on Zoom or on telephonic. I do also give the option to come in person. However, every time I send a hearing notice, I do let the litigants know, due to COVID, we would like to take safety precautions into mind. And so please let us know if you would like telephonic or Zoom. I just feel like I can't completely say no to in-person, just because more likely than not, if you're getting evicted, you may not have access to a phone or internet. And I've had some people who have specifically came in thanking me for that, because their phone's been cut off. They don't know where to go to dial into Zoom. So I do leave all 3 options available. And I think it's worked just fine. We do have limits on how many people we have in the courtroom. So before, where a docket would be 30 cases, can only hear 6 cases at a time. So I have actually now multiple dockets versus just 3 a week. I could have 12 a week, and I space them out every hour to make sure that there's enough room to hear 6 cases, let them bring evidence, discuss their case, and then enough time for us if we need to wipe down the benches before the next group comes in.
So what happened, I guess, soon after there were a lot of businesses and government agencies and such closing down in March. And then I think that the same thing happened with many of the courts, although there was a question initially, at the very least, exactly what was going to be happening. And then the Supreme Court, of course, issued the moratorium through May. So Judge Chu, what was it like during that period, for the courts, and how y'all tried to anticipate what was going to be happening and responded to people that were both litigants and both on the landlord side and the tenant side in terms of dealing with these issues?
Sure. I think when we got to before May, in between that time of March to May, it was kind of this big question mark of what to expect. We thought that there was going to be a big crunch in terms of people filing cases. Of course, in Travis County, what we had done was institute our own local moratorium or abatement. And that's kind of more or less extended out till the end of the year. The different types of cases that apply for those moratorium or abatement situations have changed just a little bit, but that still leads a big question for us of We hadn't seen, we had followed the normal trends of the state in terms of saw more eviction cases prior to the pandemic. And then all of a sudden, once the pandemic hit, we kind of took a hard nosedive in terms of the number of eviction cases filed. I think there may have been, I think there may have been a misperception amongst landlords that they couldn't still file cases in terms of when a case category was abated. But second, possibly the CARES Act protections prevented some of those cases from being filed as well. We're still seeing that similar trend right now in terms of fewer cases than on average in Travis County are being filed. And our big question really is, we know that the other shoe is going to drop in terms of once we start hearing cases, there will be a lot of evictions to be heard. And so our goal, whether it's through the advisory committee that Nelson and I are on, or whether it's through the training center or different judicial groups or within our own counties, we're trying to find ways of providing rental assistance, resolving these cases pre-judgment, and then hopefully getting those cases resolved without having to do an eviction.
And that's so, and when you're talking about what happened immediately after in March, that you're talking about the steps that Travis County judges actually took before the Supreme Court moratorium. The justice courts basically issued on with support through the governor's order essentially a moratorium on the hearing of cases, right? Is what you're talking about.
That's correct. But unless the legislature acts, there's nothing that prohibits somebody from actually filing a case. Unless you see the CDC order, that was an executive action, a federal preemption kind of situation. But in terms of state law, unless there's a legislative prohibition, nothing really prohibits somebody from filing a case. So the best thing that that the JPs, at least in Travis County, with the backing of our commissioners court, our county judge through their emergency powers, and through some other entities, we came up in concert with those organizations and our public health experts with a kind of an abatement of hearing those cases for the time being.
Right. So the landlords could still file the cases. The cases wouldn't be heard. And then, of course, there was an exception with imminent harm, possible imminent harm or imminent criminal activity.
Correct.
That was in play. So Judge Brown, can you talk a little bit about what y'all saw at the very beginning and how you dealt with both the moratoriums and then kind of the end of the moratorium with the Texas Supreme Court, what your court saw in particular?
I mean, one of the things that I want to make sure first and foremost was that the staff, the court staff were protected, right? And so we made the necessary precautions, buying masks. Our commissioners court did a real good job making sure our annexes were safe for everybody. And then kind of to Judge Chu's point, it was kind of waiting to see what would happen. Getting guidance from the Texas Supreme Court. I mean, from your advisory group, which was great, giving us guidance. But the reality is the biggest thing I was concerned with is that in my precinct, with prior to COVID, the Kinder Institute did some analysis in Harris County that 50% of folks in Harris County are renters, right? 50% of African Americans, about 48% of Hispanics are rent burdened, meaning they're paying more than 30% of their wages to rent. And looking at the stagnant wages that we have here as policy, like already folks were living paycheck to paycheck. So the anticipation of an influx of evictions was because folks were on the margins already. And because of our housing policy, particularly housing discrimination, examples like source of income discrimination of folks paying with a housing voucher, that concentration of the increased rent burden folks, a lot of it was in my precinct. And the concentrate, the poverty levels, 24% African-American, about 25% Hispanic. So it's like the increase in poverty, concentration of poverty with rent burden of folks that are in our community really is why we anticipated an influx of evictions without any interventions from the local, state, and federal level. Luckily, those interventions have happened, rent assistance, but I think a lot of us see, unless there's any other inaction, because we were already on the margins and as a community, we will see the influx of evictions.
And I think that's a big concern that we'll definitely talk about towards the end of the panel. Judge Wentworth, it's interesting. You mentioned your initial hesitance on the use of Zoom, and I suspect that you were part of many who were reticent to use some of the technology, the fear that people weren't necessarily going to be able to use it. And Judge Moreno, you mentioned some of the accommodations that you made. What are resources that y'all have found that have been helpful for, whether they're guides or whether they're, assistance of, for example, the Justice Court Training Center, the Office of Court Administration? What are the things that you have found helpful that have helped you, your staff, and litigants in this transition to more remote hearings? And I'll just throw that out to all four of you.
Well, let me just say, in my case, since I'm the oldest of the four judges here, I'm the most computer illiterate. And the thing that helped me the most was our IT department and my court manager. They're the ones that, and when I have trouble with my computer, candidly, I pick up my phone and call my court manager, who's kind of a whiz on that sort of stuff. But it's worked out really well. And I've got to say, Judge Moreno pointed out that she still has some in-person hearings. For those people that have the same problem that Judge Moreno's constituents had a problem with, we invite them to our building. I don't see them personally, but we have two different rooms in the building where we set them up with a computer and a screen so that they don't have to have a place in their home or their office. I actually had one, although I don't think it was an eviction case, I actually had one young woman a couple of weeks ago zoomed in while driving her car on a speeding ticket, if you can imagine that. I made her pull over and stop before we continued the Zoom case. But anyway, it's worked well to have those people that have a challenge at home. They do come to the court building and we put them in one of two separate offices.
Does anybody else have a facility like that?
Yeah, Nelson, I do, and I think most of the judges I think all the JPs in Travis County have something similar. I think the most important thing for us was just providing that access to technology in a situation where somebody is on the other side of that digital divide. Like Judge Moreno was saying, people who are facing eviction are likely probably dealing with situations where they can't pay bills like telephone bills or have reliable internet. So the handful of cases that we did have that are outside of our abatement case or our abatement order, we've set up, and also this goes with all of our settings in JP Court, we've set up different rooms using technology. We just call them Zoom rooms. But the idea behind that is that these people could potentially still be at risk in terms of COVID-19 or a higher risk. So we just want to make sure that we're not putting a lot of people in one room together. We want to make sure that we're still listening to social distancing guidelines or trying to put only the minimum amount of people in there. So that's why we kind of, I mean, even now our courtroom more or less is another one of these Zoom rooms, because me or one of the other judges will just hear the case from our office or our laptop. And that's the whole idea, is to continue that social distancing to keep everybody safe.
And that's a real struggle. I mean, I can tell you frankly, the balance between safety and the fair administration of justice is a real issue. And we see a lot of our clients who only have a phone to call in. In fact, I was on a hearing this morning, and it really puts litigants at a disadvantage when they can only call in. They can't see documents. They can't see who's involved in the hearing. So it's great to hear that there are those that y'all are open, that you offer those opportunities. It's a good way administer justice.
And one thing that I'm very lucky for is the fact that my wife is an elementary school teacher. So she's been teaching virtually since the pandemic started around spring break. And so that really gave me a chance to create some forms to get some feedback from her in terms of, hey, if I send this out to a court participant, would somebody understand? And her background of looking at this from a elementary school virtual background thing, that allows for this understanding of, hey, you're really explaining it to upper level. If somebody doesn't understand technology, they're not going to get that. So we've added a lot of graphics, a lot of things, what to expect and things like that. And leaning on the experiences of people outside just the courthouse community, I think had been instrumental in creating some of these changes and developments.
Judge Brown, you opened your mouth. Were you going to say something?
Yeah, I would say, Nelson, one of the things that we worked on here locally is having the city and county putting local money into legal aid services and expanding legal aid. And so in my precinct and 2 other precincts, we're doing a right to counsel pilot. And really that is for our litigants who do face that, because regardless if you can call in, regardless if you can maybe Zoom in, it's still a hearing and it's still a legal process. And the ability to have somebody with you, particularly for our vulnerable communities, to walk you through that process, we've been intentional about making that more available for more folks, not only in our individual precincts, but countywide.
That's fantastic. There have been a number of different programs. How helpful have the Supreme Court emergency orders been in terms of instructing your courts? Would you all say? Judge Wentworth?
You said, did you use the word helpful?
Yes.
Well, they've been numerous and detailed and sometimes tough to follow. As an example, the one thing that I'm chafing under currently is this rule by the Supreme Court that justice courts can't have jury trials. And as you pointed out from your initial remarks, we're the original jurisdiction court. I have a case right now that's been pending for a couple of months where I have a landlord that's saying he has a tenant that's exhibiting an imminent threat to others. There's criminal activity in that apartment. They're not paying their rent in addition to everything else. And he'd like him out, but he's hired a lawyer and the lawyer's demanded a jury trial. So this apartment manager says, hey, look, I'm living on site. I'm a resident apartment manager. I live with my wife and 2 small children, and we don't feel safe, much less the other tenants. And I tell them, I'm sorry, the tenant's got a lawyer. They've demanded a jury trial, and the Supreme Court's told me I can't have jury trials.
And that's actually exclusively for justice courts at this point, up until, what is the date?
December 15th.
December 15th, right.
Or no, I'm sorry, December 1st. But part of that order too is that the Supreme Court can only do emergency orders for 90-day periods. So I would anticipate something very similar being extended out beyond that December 1st date.
And for those that are on this call that might wonder about the reasons for that, when you pick a jury, you have maybe 40 people in one room in order to choose the jury. And so a lot of this has to do with the mechanics of actually putting that together. Judge Chu, you had I believe the first remote jury trial maybe in the country. I'm not sure.
Criminal jury trial, yeah.
Okay, so maybe you could kind of address what y'all did and some of the obstacles to getting it done.
Yeah, I think that's the only exception to the prohibition of jury trials for up until December 1st. In terms of Travis County, at least, we're gearing up to be ready for having virtual jury trials only in case of the emergency basis. Judge Wentworth's kind of case that he's outlined, those kind of cases, if we see those have jury demands, we'd be ready to act on having virtual jury trials for those. But it does take a lot of resources, and that's kind of why we're only focusing on emergency cases and don't really have a want to do them on a mass basis right now. We have to get anywhere from 20 to 30 jurors, ensure that they have adequate technology. So if somebody says, hey, I don't have internet access or I don't have the appropriate device to zoom in, Travis County has procured devices and hotspot devices to have those folks connect, and a constable will serve that device as a loaner. They sign in, and then we do our jury trial. What I figured out from doing this and being the first is essentially it drags on in terms of a normal, for example, my trial was a speeding ticket trial. Normally those are 3 hours maximum if we were doing this in person pre-pandemic. And this lasted from 8:30 to 6 o'clock when I did that in August. And I anticipate that that's going to be something very similar when we do these kind of trials in the future. Now, one of our big things too is that in that criminal case, we found it easier to have that trial if there were attorneys on both sides. Obviously, the state's represented by an attorney, and then the defendant. We got an attorney for them pro bono, but I imagine for an eviction case or a civil emergency case too, we would probably want to partner up with Volunteer Legal Services or Legal Aid or any one of the various groups in Austin to set up attorneys at least on both sides to make sure that things go smoothly. But it's pretty difficult to implement. But the one thing that I do think is helpful is the fact that for a lot of these things from the streaming court orders are very generic. And I know usually with like something very specific and processes and procedures, but I found that as a great opportunity for us to see where our guideline is and then go from there and kind of innovate and implement those innovations how we see fit. So I kind of see kind of like the carte blanche decisions by the Supreme Court are on these orders as an opportunity for us to do what we want to that we think are best for us until we get mandamus or told otherwise by an opinion or something.
And that was, of course, that there were a series of Supreme Court emergency orders that allowed the courts a little bit of leeway in terms of deadlines and filings and things of that sort. And I think most courts took advantage of those types of things to develop their, what was best probably for them, what was hopefully best for what was for them. The 25th emergency order, of course, deals with the CDC order. And I'm curious about what y'all are seeing with regard to the CDC order and the implementation of that order. I saw you nod, Judge Moreno. You want to talk a little bit about that?
Sure. When we first read the CDC order and we were wondering first, did they have the authority to do so? So I think, at least in our county, we were trying to figure out, okay, logistically, how is this going to work? Because we already had restarted cases. We had our own county moratorium that ended August 24th to be in line with the CARES Act. So that as soon as we're getting ready to get started, then the CDC order comes out. And so we kind of expected that there was going to be, another downward spiral in terms of filing. But, I think unfortunately, with the elections and other things that are going on in this country, I think some of that news gets lost. And so we've actually seen an increase in filings, which has surprised me. And I'm just not sure if it's just that landlords are just at this point ready to take a gamble and hope that the tenant didn't file a declaration, because, if they do, a lot of times they're coming up, since the Supreme Court does require us to now provide the declaration to the tenants, who are just showing up day of court, like, here you go. And the landlord is kind of at a loss. And, we do ask, are you going to contest? But a lot of times they just don't feel like they're prepared to contest, or they didn't really understand what the CDC order meant. So I would say we're kind of starting to get back to normal in terms of filings, but of actual cases that proceed, I would say it's about 50-50. We probably abate 50% of the cases. And we're still getting a bunch of defaults. So that means the tenants also are not understanding their rights. They're not reading the citation, reading that they have this option. So I'll be interested to see when we also have to implement the new order with the diversion program, what that will mean for filings. But for now, we're still moving forward. And the only thing too that, you know, during a hearing, is this part of the CARES Act? Did you, if it's so, did you comply with a 30-day notice? Great. Okay. Is there a CDC order declaration? It's kind of now a list of things that we as judges have to make sure we're checking off all our boxes, just because now there's so many laws in play. And again, if a tenant comes in, well, what's the CDC declaration? I don't think it is we gave them the information, but I can't specifically, I think, tell them that they should sign it. I just said it was with information. If you believe you're covered, then you can sign it. If not, we're proceeding today.
And for
So
the people, on the call that may not be, I'm sorry to interrupt, that may not be aware, I didn't explain what the CDC order was, but for those that you may not know, it is a moratorium order that was imposed by, or issued by the CDC, that allows a tenant to sign a declaration stating essentially that that's a non-payment issue, that they've had a substantial loss of income, that they've attempted to pay the rent to the extent that they could, and they're looking for additional rent, and they fall below a certain income guidelines. I think it's $99,000. So, and if they qualify for that, they can sign this declaration. They then give it to the landlord. And the 25th emergency order by the Supreme Court says that if they do that and they file it with the court, then the court is supposed to abate the eviction process for the period of the moratorium, which is essentially through the end of this year, December 31st. It does not cancel rent. It does not, there's still the obligation for the landlord, for the tenant to keep up, to try to get the rent, try to raise the rent. Judge Brown, what have you seen with regard to the CDC order in the filings in your court, and how has your court dealt with that?
I mean, the filings are still consistent because it's incumbent of the tenant to file the affidavit. To Judge Moreno's point, some people do and some people don't, right? And I still have a lot of defaults. But again, it makes the point that there are other systems, there are other mechanisms that we should pursue. And I'm glad even on the Texas Eviction Diversion program that there was money available for legal aid services. And locally, we've done that because these are legal documents. And I can't, in good conscience, first of all, you give somebody information. If they sign something on a penalty of perjury that can, produce jail time, particularly if a landlord protested, like that again, as a due process issue. And again, that's why I'm raising the issue for legal aid, particularly for low income tenants, because they have to balance, do I get evicted or am I perjuring myself, right? And so maybe they don't even want to say anything. And so that all being said, we're still having filings like under the CARES Act. We still had filings, right? But it's incumbent the court, and the Supreme Court has given us guidance how to do under the CARES Act and the CDC. But those concerns still, I do still have those concerns under the CDC affidavit.
Sure. And I think, a number of y'all have addressed the fact that people just don't know what is happening, or frankly, how they should interpret some of these things. And so it's better. I'm sorry, go ahead.
Literally, we had to when we got the order and affidavit, us as JPs didn't know what to do. We had to get guidance from the Texas Supreme Court, and that was convoluted. So imagine somebody facing a crisis of eviction. If you give them information of a CDC order, like, what does that actually mean?
Right. No, I know. I think that's, which is why I think in a lot of ways it is important for there to be guidance, at least, certainly from the Texas Supreme Court, or, top down, to say this is how, you should be looking at some of these things. Because without that, I think one of the complaints that we would see, at least in the first months, or certainly in the first couple of weeks, but certainly in the first months, was, what are we supposed to be doing? And a lot of people were just kind of making it up, sometimes really working and sometimes simply not. In the last couple minutes before we turn over to questions, let's talk a little bit about the last thing that Judge Moreno, you mentioned, which is the Eviction Diversion Program. So that is the 27th emergency order. It is a program that has been developed by the Governor's Office, the Office of Court Administration, and the Texas Supreme Court. And essentially, it is a $170 million rental assistance program for people who are in non-payment of rent cases in justice court. The Supreme Court order says that if the landlord and the tenant agree, join the program and make sure that the landlord gets paid for the back amounts, that the case is abated for 60 days. The landlord can choose, I guess, if there's a problem, to go back into the process, but if the landlord chooses not to, then the case is dismissed with prejudice. And not only that the case is essentially confidential. It can't be used against the tenant, which is a good thing, certainly in a lot of the cases these days. I can tell you, just based on our experience, we have so many people that are applying for legal services that have never applied before. They're losing their jobs, for the first time, and there's a lot of difficulty out there. So let me see. Let me go back to you, Judge Brown, because I think that you may be the only one who is in the pilot program, your office, right?
No, I am as well.
Oh, Judge Wentworth. Oh, good. Well, then we'll start with you, Judge Wentworth. What do you know about the eviction diversion program based on what people are telling you, and how were you hoping that it will work in your court?
Well, I read all that information that was sent last week. It became effective at 8 o'clock yesterday morning. I had an eviction docket yesterday afternoon at 3, and I had about a dozen cases, and 2 of them wound up both the landlord and the tenant wanted to participate in the program. So I referred those 2 cases. And as you've already explained, for the next 60 days, the file is confidential. The question I have, though, and I don't have an answer for it from anybody, is what do they do now? I mean, I've done what I'm supposed to do. They've agreed to participate in the program, and I've referred them to the program, but we don't have any forms to fill out. We don't know who makes the next move, the landlord or the tenant. So we're kind of waiting on that answer. But I've referred 2 cases as of yesterday.
Great. And my understanding is that they will pay a number of months and maybe even prospectively as well if the program works. I suspect that there will be a development of more rules as the program is developed, just because from the pilot program to statewide, there's going to be I think a leap. Judge Moreno, were you going to say something?
I mean, I think my biggest question and concern, even though I'm not a pilot county, but when I first read the orders, it tells, if the landlord within 60 days decides to reopen the case and take it out of abatement, I mean, is there certain rules that they're allowed to do that? What if they are participating in the program, they're doing everything right, and then they just decide to restart it? Or where is that checks and balance, I think? Because I don't know if that's at this point, I don't know if it's clear who or what, as judges, are we supposed to ask? Are you still in the program to move forward? I just don't understand how we're going to be able to check that to confirm that we can proceed again, or that it still has to remain abated. And if other judges have their thoughts and opinions on that, to me, that's my biggest concern about how to implement that.
Judge Brown, have they addressed
my assumption was that they let the tenant get out of the program if during that 60-day period, for whatever reason, the money doesn't come forward to the landlord. And among the disqualifiers are, if the tenant has already received some kind of rental assistance at the local level, they're not eligible for the eviction diversion money.
One distinction for that, Judge Wentworth, is that it's if they receive local money for the periods that are being asked. So, so in a situation of like, if you got Travis County money in March, but you're applying in the program for April through June, you would still be able to do that.
Right.
But there's no mandatory requirement that would be part of the filing, right? That they just can
not that I understand,
start the case, and then we just ask those questions at a hearing, right? And that would be the burden of proof is on the landlord to say that negotiations have fallen through.
So there's a pleading requirement for the landlord that they have to say that they reviewed the information on the Texas Diversion program website, but then the judge is supposed to, at a hearing, outline the procedures and then see if they want to do that, abate the case for 60 days. Now, the onus is on the landlord in those 60 days to say, open the case back up. I think program wise, they had assumed, and the state, by they, I mean the state people, had assumed that if you're in or out of that program, the landlord would get notification along with the tenant that they are in or out. And so within the 60 days, the landlord would have to say, open the case back up, likely because they got rejected from the program. Otherwise, the default would be dismissed with prejudice if the landlord never got back to it. So I think in terms of court processes, it's kind of easy for us just because it's essentially once we hit the abatement window, we just wait 60 days or wait till there's a motion to unabate essentially. And then we kind of go from there.
But a lot of questions, and I guess one of the last questions I would have about the eviction diversion program before we get to questions that people have, but is the kind of the interaction between the CDC order and the eviction diversion program. And it seems to me that there are going to be a lot of people who have filed with the court CDC orders and the court has abated them, who really could benefit from the eviction diversion program. And I'm wondering if any of y'all are intending on informing those parties, both the landlord and the tenant, that of the eviction diversion program, so that they might be able to benefit from it.
I am in my court. The way we've kind of worked around the moratorium part of it is that we plan on setting status hearings on all these cases to explain the eviction diversion program to folks. And the reason why we call it status hearings is so that there really isn't a consequence for people not showing up to those settings. But that gives an opportunity to actually get that information out there and hopefully get the ball rolling on those cases. Well, I also see the fact that like eventually at some point, we're just going to have a bunch of eviction cases that Travis County is going to hear. So if we can kind of cut some of these while we still can, that would be advantageous. So that's our solution to that issue.
Great. I'm going to go ahead and in the last minutes, take some questions here, and I'm looking. It looks like there's some questions in the chat that I should have been looking at, but wasn't. This one is. Here's one about CDC declaration objections. How do you all deal with basically motions from landlords disputing a CDC declaration?
In my court, I set a hearing and have them come in and present whatever evidence they've got to dispute it.
And when you say they, you mean the landlords bear the burden to present evidence that they actually that they know
Correct.
that there's something wrong.
I've only had one of those thus far, but the landlord came in and objected, said that they hadn't been seeking rental assistance anywhere else, and just perjured themselves by signing the declaration. I
see. Anybody else? How do you all deal with these disputes?
So Nelson, I haven't gotten any landlords to dispute, but what I plan to do is set it for a hearing, as Judge Wentworth said, but also appoint a counsel for the tenant if they if in the interest of justice, particularly if they're low-income tenants. Just because, again, the wording of the order, I just don't want them to the balance of perjuring themselves and being evicted. And so appointing counsel in those cases, particularly for low-income tenants.
And I haven't gotten any either.
I have. I just will ask them too, because sometimes the tenant will come with a declaration at the hearing. So I will ask the landlord at that point in time, are you going to have objections to the declaration, or so we can either discuss this or reset it for a new hearing, or if they say they're not going to object, that they agree and they're okay with the abatement, then I'll abate it right then and there.
And
versus
I think
having them come in again.
Right, and I think that the Supreme Court emergency order actually addresses this, but one of the questions was if the tenant presents and I think you just answered this, if the tenant presents a signed CD order that they've already given to the landlord, to the judge, and the landlord at the hearing, then will they be in the clear? I assume that what they mean by that is the case then abated, and I assume the way that you can tell me this right or not, I assume the way that your courts would deal with this is that you would abate the case unless the landlord at that point were to object and dispute that, in which case you would probably set it for a hearing. And the burden is on the court. The emergency order does make it clear that the burden is on the court to actually issue a decision as to why that's denied. So I'm sure it's something that you have to consider carefully. Are landlords allowed to file a new eviction for non-payment of rent after having an eviction abated with a CDC order from the same tenant? Have you seen anything like this?
I haven't seen that, no.
No.
I think from the CDC order, I think people need to understand that filing the moratorium declaration isn't case specific, even though there may be a cause number reference to it. If as a tenant, I filed the CDC order, that is supposed to put a moratorium on an eviction, regardless of where the landlord status is on the case. So I think the fear is that the landlord would try to dismiss the case so that he can then file it again. And hopefully they don't refile a CDC moratorium. But if the law's applied correctly, it should be abated automatically at that point. Or and also sanctions probably should be given to the landlord for filing outside of the applicable moratorium.
So here's a technical question from, I assume, an attorney. If there's a procedural issue like notice, are you dismissing the case if the tenant proves that there was a procedural issue? And I'm assuming that would be like a notice to vacate problem, or the landlord didn't plead properly about whether or not there was a CDC order or the CARES Act. How do your courts deal with that, if you want to respond?
Yeah, I dismiss it.
I do.
Yeah.
Yeah, if I notice something like that, I'll just set it for a pretrial just to hear it out. But I mean, yeah, that's a dismissal right there.
Yeah, to me, if I have a procedural issue, I don't even get to the CDC order, the CARES Act, because they didn't have the correct pleadings to proceed with the case in general. So that would have been my decision, regardless of all the other orders in play.
So let me ask you kind of one of our final questions, because we're at the bottom of the hour, at 1:30. Where do you see your court going in 2021? Will you be adopting remote hearings as part of your repertoire? Are there things that you anticipate just because of what you're seeing in the courts now, that may be happening in the court in 2021? And maybe I'll give each one of y'all an opportunity to talk to close it out. Maybe we'll start with you, Judge Chu.
Sure. I think, paradigm-wise, I think we're in the long haul. Even if there's a vaccine, there's a distribution issue. So earliest I've been hearing from public health people is summer of 2021. So we need to understand that these processes still need to continue and fine-tuned and things like that. I think there's no going back. I think in my court, we'll probably have some level of Zoom or remote hearings in that process because I do see, even though there are these issues with access to technology, they do provide a larger basis for folks to participate that normally wouldn't. I'm seeing a lot more show-up rates than in the past because I think it's easier than getting downtown to where I'm at. And so I think this is a good tool. It isn't going to be how it is forever, but it's a tool, and it's going to be a helpful tool for judges to dispense cases.
Judge Wentworth, what do you see for the future?
I see a tsunami of eviction suits being filed in January. As soon as that December 31st abatement termination date comes around. As you've pointed out earlier, the rent continues to accrue, late fees continue to accrue, and the people are not saving up the money to pay this huge lump sum at the end of December. So I think we're going to see a whole ton of eviction suits filed if the landlords don't file them right now. I mean, they can file them right now according to the federal guidelines. Yeah. So I think we're going to be real busy, and I think we're going to continue, in my court at least, to do nearly all of them remotely. I'll be stuck in my chambers with the clerk and a stack of cases for quite a while, I suspect.
And hopefully with a little luck, the eviction diversion program will release a little bit of that, but I suspect that money will go very quickly. Judge Moreno, how about you? What do you see for the future?
And I'll echo my colleagues that I think that Zoom telephonic hearings are here to stay for quite some time or forever, and that we'll always just have to have multiple options so that people can access our courts now and in the future. In terms of eviction filings, I don't see a huge wave because a lot of filings are still coming in as is. And so if the case does get abated, or if they're part of the diversion program, then I do think that they will find ways. I've had a lot of landlords who, when our own county moratorium, were able to work something out. And so they ended up dismissing. I had a lot of dismissals when our moratorium finally lifted. And so I'm hopeful that that will happen with either the CDC moratorium or the diversion program, that even though we have consistent filings, that in January, it's not going to be a wave, and that they've had plenty of time to work that out. And so maybe I'm going to be optimistic about that and just hope that that's how it works out.
Judge Brown?
I echo all my colleagues. I would add an extra piece. And Judge Wentworth, you'll appreciate this. The legislative will be in session in January. And at the end of the day, this crisis moment, particularly as it relates to eviction, this is how good public policy, or hopefully good public policy can be, that can be a result of it. And so right now, all emergency rental assistance is from the federal level, right? You know, if the state will put in local money, state put in state money, local entities, Harris County put local money into these efforts to pay the back rent, and also look at what tenant protections we have and don't have to keep folks housed. And I think our friends in the legislature would look at this moment and look at the crisis of the moment and look at not only short-term solutions, but long-term as well.
Great words. Thank you very much, Judge Brown. I think we are a little bit over, but I wanted to thank you all very much for your wisdom and your time. Christina, did you want to say anything at the very end?
Nope, that's it. I just want to advise everybody that all of the information that we talked about at the front end of the call will be available on our social media. So you can look at Facebook, Instagram, Twitter for links. And this will stay on our Facebook page. So if you want to pass it along to someone to watch, please do that. But thank you very much for joining this call. We appreciate our community of housers and advocates and people just interested in the topic. So thank you.
Judge Chu, Judge Wentworth, Judge Moreno, and Judge Brown, thank you so much for participating.
Thank you. And thank you.
Thank you. You bet.
All right. Take care, everybody.